Welcome back to one more session. Today in this session I am going to explain about restitution of conjugal rights. Restitution of conjugal rights is one of the remedy which is available in matrimonial disputes. So what is restitution of conjugal rights? Restitution is nothing but restoring, and a conjugal means relationship between a married couple. So a suit for restitution of conjugal rights is one of the a species of matrimonial relief. It is brought when either the husband or the wife lives separate from the other without any sufficient reason. In that case, the court will compel them to come together again. Restitution of conjugal rights according with Hindu law. Section 9 of Hindu Marriage Act provides a provision for the Section 9 of Hindu Marriage Act provides a provision for the restitution of conjugal rights. According to the Section 9 of Hindu Marriage Act, when either the husband or the wife has without reasonable excuse withdrawn from the society of the other, aggrieved party may apply by petition to the district court for restitution of conjugal rights, and the court, on being satisfied of the truth of the statements made in such petition and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. So, where a question arises whether there has been reasonable excuse for withdrawal from the society, the burden of proving reasonable excuse shall be on the person who has withdrawn from the society. The main principle involved in this section is each one of the parties to a marriage has a right to society and consortium of the other partner. When this basic right is broken by the spouse, the other has a right to relief under this section, Section 9 of Hindu Marriage Act. What the petitioner has to prove to brought this suit? To be able to demand a restitution successfully, the following must be proved. The things to be proved is one of the spouse has without reasonable cause left the society of the other. The petitioner must assure the court that the causes stated in the petition are true and there is no legal reason for the court not to grant such relief. So, whatever the causes mentioned by the petitioner, everything should be true. These are things need to be proven by the petitioner. To oppose a petition for restitution of conjugal rights, for defense for this restitution of conjugal rights, opposition for the purpose can be done on account of two reasons. Only on the basis of two reasons can be refused or oppose the RCR petition, restitution of conjugal rights. One of the ground is cruelty, adultery or desertion, or otherwise any serious reason. Based on this, uh, restitution of conjugal rights can be opposed by the opposite person. The popular case laws based on this restitution of conjugal rights is T. Sarita versus T. Venkat Subbaya. Once go through the facts of this case, the parties were married under the Hindu Marriage Act. Wife left the matrimonial home. husband filed a petition for restitution of conjugal rights under Section 9 of the Hindu Marriage Act. So then in district court, husband was approached district court to defend herself. A wife went to Andhra Pradesh High Court. The court held that Article 21 of the Constitution of India guarantees right to life and personal liberty and right to privacy, including marital privacy. Restitution of conjugal rights violates these rights as it denies the person right of free choice. Article 14 of the Constitution of India guarantees right to equality and equal protection of law is also violated. Though the section does not discriminate between husband and wife and makes the remedy available to both equally, but in reality it is more in favor of the husband. So the Andhra Pradesh High Court held that Section 9 of the Hindu Marriage Act was unconstitutional. Section 9 of the Hindu Marriage Act was unconstitutional, was held by Andhra Pradesh High Court. Later on, in another case, Harvinder Kaur versus Harminder Singh. Harvinder Kaur versus Harminder Singh. In this case, the facts of this case is husband and wife were married under Hindu Marriage Act. Wife left her matrimonial home. Husband filed a petition for restitution of conjugal rights under Section 9 of Hindu Marriage Act. Wife challenged the constitutional validity of section. In this case, the Delhi High Court strongly dissented with the Andhra Pradesh High Court's view. Courts held that restitution of conjugal rights aims at cohabitation and consortium. The essence of marriage is cohabitation, and the court orders restitution of conjugal rights only for stabilizing the marriage and encouraging reconciliation. Therefore, the provision of restitution does not violate the constitutional provision of equality and privacy. Further, the constitutional law principles cannot be applied to family law. This is the view of Delhi High Court in the case of Harminder Kaur versus Harminder Singh. Later on, the Supreme Court in Saroja Rani versus Sudarshan Kumar Chada was overruled the decision of T. Sarita versus T. Venkat Subbaiah. The Supreme Court observed that the object of the restitution decree is to bring about cohabitation between the estranged parties so that they can live together in the matrimonial home in amity. The court further said that introduction of constitutional law into a matrimonial home was like introduction of a bull in a china shop, which would not desist from violating it. However, apart from arguments in favor and against this provision, the famous writer Dr. Paras Diwan his opinion that this provision should be abolished from law and instead the theory of irretrievable breakdown of marriage be introduced, which would be very beneficial to the parties. This is the restitution of conjugal rights and famous case laws with respect to the RCR under Section 9 of Hindu Marriage Act. Thank you.